Good afternoon, everybody. I'm just going to give this a minute or so as people filter in, and then we'll get started. If you're just joining us, we're giving everybody a minute or so to filter in, and we will get started shortly. That seems to have slowed down. So why don't we go ahead and get things going as people still continue to filter in. So good afternoon again, everybody on the line. Thank you for joining us and welcome to our webinar on California's new campaign contribution regulations, what local governments need to know. My name is Melissa Keene. I'm a senior program manager with the Institute for Local Government, and I will be your host and moderator this afternoon. In terms of an agenda, we're just going to do a quick welcome. Our panelists are going to talk through some of the updates to the Political Reform Act and the regulations around that. Then we do have some time for audience Q&A, and we plan to wrap up and adjourn by 1 o'clock this afternoon. Just some quick housekeeping before we get started. You probably have noticed that you're on mute, and you will be on mute for the duration of today's webinar, just due to the size of the audience that we're expecting. Just wanted to streamline that a little bit, but we are accepting questions. You should see a Q&A box on the bottom of your screen and the control panels there. Please feel free to type questions into us at any point during today's webinar. We're keeping an eye on that. We'll respond to anything that's logistical or tech related, and then we'll put all the rest of the questions in the queue for the panelists that we'll get to at the end of today's webinar. We also are recording today's session that you probably noticed when you jumped in, and we will be distributing the slide deck as well as the recording for this webinar in the next week or so. It'll all be posted on our website, and you will get a link, a direct link to that via email. So I want to share just a little bit about ILG before we get started, in case you're not super familiar with us. So ILG is an affiliate of the League of California Cities, the California State Association of Counties, and the California Special Districts Association. So we work together with our affiliates to really help serve cities, counties, and special districts statewide and provide practical and easy to use resources so that you all as local agencies can effectively implement policies on the ground. So we do this in a number of ways. We do a lot of education and training like this webinar, but we also do conference sessions. We do in-person and virtual trainings in a longer format. We also provide technical assistance and capacity building services for local agencies, as well as convenings, as well as written and online resources for you all. We have 4 main focus areas, the first of which is leadership and governance, which is tied into today's topic. But that's really the foundational piece for local agencies, the state mandated trainings, information on new laws and regulations like we'll be talking about this afternoon, and then information on how to work together as a governance team, how to work as an effective council or board, work with staff, work with the community. In addition to that, we have a program focused on civics education and workforce, which helps local agencies navigate some of the recruitment and retention challenges right now, help create a pipeline to public service, get young folks interested in local government as a career path, things of that nature. We have a whole program focused on public engagement, so really helping local agencies embed community engagement into their processes, thinking about it a little bit more strategically and authentically so that you can come up with systems instead of doing one-off engagement efforts, and really thinking through it from a more equitable and authentic standpoint. And then lastly, we have a program focused on sustainable and resilient communities. Right now, that program is doing a lot around housing and land use, but we also do a lot of work around climate resilience. We run an awards program to honor cities, counties, and districts' efforts to reduce greenhouse gas emissions, save energy, implement sustainability best practices, and things of that nature. So a lot of free resources and training for you all on the line. So if you haven't already, definitely look at our website and find out how we might be able to help you and work through some of the challenges you might be facing. Want to quickly introduce our presenters this afternoon before I turn it over to them to really jump into the content. So first, we are joined by Craig Steele. He is a shareholder in the Public Law Department at Richards, Watson & Gershon and serves on the firm's management committee. Mr. Steele has over 30 years of experience practicing local government law and has worked in government and politics for over 35 years. Mr. Steele is the city attorney for the city of Monrovia, general counsel to the Nipomo Community Services District, and senior counsel to the Los Angeles County Children and Families First Proposition 10 Committee, First Fight LA. A former political campaign manager, Mr. Steele is an expert in elections, voting rights, and government ethics laws, and has frequently been asked to speak and teach on those subjects by the League of California Cities, us at ILG, the California Special Districts Association, and other organizations. We're also joined by Natalie Kabakian. She is an associate attorney in the Public Law Department at Richards, Watson & Gershon, advising cities and other local agencies on various municipal law matters. Natalie gained experience in political campaigns as a city council campaign manager after college. During law school, Natalie clerked at a civil appellate boutique firm, argued before the Ninth Circuit Court of Appeals on behalf of an asylum seeker, and served as editor-in-chief of the Loyola of Los Angeles Entertainment Law Review. She has written extensively on California Assembly Bill 5's potential impacts on the video game industry unionization, and previously interned at the National Labor Relations Board and collaborated with the California Division of Labor Standards Enforcement as a clinical student. Her article on the Supreme Court's recent firearm licensing decision has also been published in the League of California Cities Western City magazine. So with that, I'm going to turn it over to Craig and Natalie to get us started on today's topic.
Okay, thank you, Melissa. We appreciate Melissa and Taylor from the ILG for helping with this presentation and organizing the seminar. Welcome, everybody. We're going to talk about SB 1439 and its recent amendments to Government Code Section 84308, which have significantly changed the landscape of California's conflict of interest laws for elected officials and appointed officials, and the way that they will have to think about campaign fundraising. For my entire 30+ year career, we have been advising elected officials that a campaign contribution in any amount does not create a conflict of interest that requires disclosure and recusal under the Political Reform Act. That's always been the law for elected officials since I've been practicing, and the consistent advice that we've given. SB 1439 changes that advice for contributions over $250 in a year. And we hope to walk you through these provisions, the major parts of this law, and give you some examples to help you understand the new rules. There were some questions that were submitted in advance, and I see some more have come in the Q&A since we started. The questions all kind of seem to fit into a couple of different buckets, and we're gonna answer the questions that were submitted in advance during the presentation, and I suspect that the questions that are being submitted now probably fall into some of those same buckets. So we'll try to hit those as we go along. There were a couple of other questions that were submitted regarding some other conflict of interest issues not related to this bill, and we're not going to try to address those here. As always, in a seminar like this, we're trying to give you enough of an overview to help you stay out of trouble. But more important, in my view, is we're trying to give you just enough baseline knowledge to help elected and appointed officials know when to ask for advice from a lawyer or from staff. And if you are staff or you are a lawyer, how to help support your elected and appointed officials on this issue. Because the burden for compliance and the penalties fall on the individual officials for the most part, just like in a normal conflict of interest analysis. The filing officer in each jurisdiction is not responsible, not legally required to track contributions under this particular law. But it may turn out to be a good idea to try and find ways to do that to help elected and appointed officials comply. The FPPC has been designated to enforce Government Code Section 84308. And the FPPC has already indicated in writing that they are actively monitoring compliance by local officials with this new change to this government code section. Next slide, please. So in this presentation, we're going to talk about these points. We're going to talk about the officials that were impacted by the law. We're going to talk about the definition of parties and participants, provide some suggestions about how candidates can adjust campaign fundraising, talk about other terms like a pending proceeding. We're going to talk about what willful and knowing means in the context of receipt of a contribution. We're going to give some tips on how appointed and elected officials can cure violations. And we're going to answer the question of whether this law impacts PAC and independent expenditure fundraising. Next slide, please. Government Code Section 84308 has been around for a while. It's been known as the Levine Act of 1982. It was the product of the state legislature coming out of an alleged, well, it wasn't alleged, it was actually established in court, pay-to-play scheme involving appointed members of the California Coastal Commission. And it was an anti-corruption law. And there was allegations that appointees to a commission had raised campaign contributions for elected officials and candidates, and did so in a way that created conflicts of interest because they voted the way the contributors wanted them to vote. SB 1439 is authored by Senator Stephen Glazer, who said that public trust is greatly enhanced when decision makers maintain their independence from these corrupting influences. These corrupting influences refers to a couple more recent examples of alleged pay-to-play schemes in cities like Los Angeles, where there's been a lot of media attention, and a few others. And the intent of the author of this bill was to, quote, close the loophole, because 84308 previously only applied to appointed officials and not to elected officials, and covered contributions to officials who are acting in an appointed capacity. As you'll see now, 84308 now applies to both appointed and elected officials and donations to their political campaigns. Next slide, please. Here's a summary to try to just give you an introduction to the terms that Natalie is going to walk through in a minute. This is now what 84308 says, and I would recommend that you Google the section and read it yourself after this presentation is over, because this is just a summary, and there's a lot of meat to this particular statute, so it would be worth your while to take a look at it. Basically, this law now says that while a proceeding is pending and for 12 months after a final decision, an officer may not accept, solicit, or direct a contribution of more than $250 from a party, participant with a financial interest, or that participant's agent. Prior to participating in the decision, an officer who received a contribution of more than $250 in the previous 12 months from a party, participant, or agent must disclose that contribution and recuse themselves from the proceeding and the decision. Helpfully, I think, we're going to talk about this, officers have the opportunity to cure some violations within a specified time frame. And so there are ways to lawfully participate, even though the officer may have already, within a short period of time, received a contribution of more than $250. A party to a proceeding who made a contribution of more than $250 to an officer in the previous 12 months must disclose that contribution on the record of the proceeding. So that's the responsibility of the contributor, who is then a party to a proceeding before a public agency. That contribution of more than $250 has to be disclosed. So that will help, hopefully, public officials understand what's going on with their contributors. And the last point to emphasize is that parties, participants, and agents may not make contributions of more than $250 to officers in the 12 months following the date of an agency decision. I want to emphasize a couple of points here. One is that this applies to appointed officials, elected officials, and candidates. It applies to parties and participants to a proceeding that we're going to talk about those definitions in a minute. It applies to contributions at every level of election. So contributions to federal campaigns, to state campaigns, to county campaigns and local campaigns. All of those contributions are covered by these limits. And for the most part, these limits are not different from what previously applied only to appointed officials. So if you were an appointed official, a planning commissioner, for example, running for city council, you were already hopefully aware of these limitations because they already apply to you. Finally, as Natalie's going to go over in a minute, the concept of a proceeding is a very long and sort of unlimited almost definition. A proceeding can start when an application, for example, is made and staff starts considering something and working through the aspects of a, for example, land use decision, and can even extend past the date that the city council or the decision-making body makes a decision. Can also go, and we had a question about this, to the point at which, for example, a mayor has to decide whether to sign or veto a decision made by a city council in a city where that's applicable. So it's not just the actual vote on a particular issue. The concept of a proceeding can be broader than that. Next slide, please. And we'll turn it over to Natalie to walk through the legislative changes.
Thanks, Craig. As Craig just mentioned, the authors of this law sought to remove the exemption that existed since the 1980s for local elected officials voting on matters involving campaign contributions. But before we discuss the main changes introduced by SB 1439 in depth, let's first take a step back to discuss the previous Government Code Section 84308, and before we highlight the changes. Previously, the requirements to disclose and recuse, as well as to avoid accepting contributions for a period after a decision, applied only to appointed, non-elected local or state agency officers. This might have also applied to elected officials acting in their appointed roles. An example would include for a city council member appointed to a board of joint powers authority or a commission. It also, under the old law, the fundraising ban for post-proceeding contributions over $250 was limited to 3 months after the final decision, and that has since been changed. So why is the former law important and relevant to us? Although the FPPC has advised recently that the law does not apply retroactively, and we're yet to receive a definitive answer from the Attorney General's office on that, the old law is relevant to any contributions received in 2022, as well as any proceedings participated in before the effective date. So in other words, a proceeding that an appointed official would have participated in sometime in 2022 would only limit an appointed official for 3 months for purposes of the fundraising ban. Now, for the amended provisions, these prohibitions and requirements are effective as of January 1, 2023. So it's forward-looking for now. Under this law, there have been 2 main changes. The first we will unpack. The first point we'll unpack in greater detail throughout this presentation. The law broadened the fundraising prohibitions and recusal requirements to include local elected officers. So the legislature simply broadened the term officer to be more inclusive. And next, the fundraising ban for post-proceeding contributions over $250 was extended from 3 months to 12 months after the final decision. Next slide, please. So who's actually impacted by this law? As we stated, they're officers, so any state or local agency officers, This includes elected or appointed officers, alternates, and candidates for elected office. Who is excluded? Members of the judicial branch and courts, and governor's cabinet members. Examples might include, and this is not exhaustive, but members of city councils, county and special district boards, as well as appointed boards. Next slide, please. Now, first, let's review the amended disclosure and recusal requirements. Under SB 1439, a campaign contribution can create a conflict of interest, much like an economic interest. So under the new law, an officer who received contributions of more than $250 from a participant or a party, and for a participant, it's someone who the officer knows or knows has a financial interest in the 12 months prior to rendering a decision, must first disclose the fact on the record, and second, recuse herself from the proceeding. So this would also include agents like attorneys or lobbyists. The regulations clarify that an officer cannot make, participate in making, or attempt to use her official position to influence the decision if she willfully or knowingly received a contribution from the party or a participant with a financial interest. So this would not include all contributions. It's only those that were willfully or knowingly accepted. But what does that mean? We can move on to the next slide, please. So what is the willful and knowing receipt of a disqualifying contribution? So as an official, you might worry that anything you receive would impart knowledge on you such that these new requirements would be triggered. That's not actually true, but let's go through what would actually qualify as willful and knowing. So the first is pretty straightforward. It's actual knowledge. If you actually know about the contribution that you received, if it was handed to you in person, or if your treasurer told you personally about this donation that was made, that's actual knowledge. So if you receive that, then the new provisions are triggered. The second is about the party's disclosure requirements. So if a party to a proceeding before the agency involving the license, permit, or use entitlement discloses the contribution made on behalf of himself or even his agent within the preceding 12 months as required pursuant to the government code, then that imparts knowledge on the official. We should note that participants don't typically, apart from one example, have to disclose their contributions, but parties should under the government code. So if they disclose this contribution, then that would mean that the official knows and therefore should take steps to recuse himself. Next, if the official is aware of facts establishing other reasons to note the contribution. So the regulations offer these examples. From my understanding, it's not exhaustive, but an example would include if someone was informed, if the officer was informed by someone, if a party or participant previously made 2 or more contributions over $250. So what would that mean? That would mean that's a repeat donor. That's someone that the officials should presumably know. So that would mean that he knows about the contribution. A personal solicitation or even a personal acceptance. If you accepted as an official a check during a fundraising event, that would mean that you have willfully and knowingly received the contribution. But not everything constitutes actual knowledge. For instance, a contribution recording alone does not constitute knowledge. For instance, if your campaign treasurer were to file a Form 460 to report contributions, that filing alone is not sufficient to constitute willful and knowing receipt. Now, if there are other facts to suggest that you know about that filing, then that would constitute willful and knowing receipt. Next slide, please. Next is the fundraising ban. Under SB 1439, an officer cannot accept, solicit, or direct a contribution over $250 from any participant, party, or their agent. And again, for participants, an officer needs to know or have a reason to know that the participant has a financial interest. While a proceeding involving a licensed, permit, or other use entitlement is pending, and for 12 months following the final decision. So again, this fundraising ban has been extended from 3 to 12 months. So any proceedings that took place after January 1, 2023 would be subject to this timeline. So what kind of contracts, licenses, and permits are covered under this? Not everything. Any business, professional, trade, franchise, and land use contracts would be included. Examples might be conditional use permits for businesses to do construction, development permits, as well as professional service contracts. But again, this new requirement does not cover all contracts. What's excluded are competitively bid, labor contracts, and personal employment contracts. Usually competitively bid contracts afford officials less discretion, and that's why presumably it's been excluded. Next slide, please. So when is a proceeding actually pending for purposes of the fundraising ban? A proceeding has commenced and is pending when, and the commission has identified two different situations in the regulations. For an officer, it's when a decision is before the officer's consideration as an item on a public meeting agenda, or the officer knows or has reason to know the proceeding is before the agency's jurisdiction for its decision, and it's reasonably foreseeable that the decision will come before the officer. So for parties, participants, or agents, presumably for the disclosure requirement for parties, a proceeding is pending when a decision is before the agency's jurisdiction for a decision. So that's the distinction that's made in the regulations. Next slide, please. So this new law has introduced a new conflict of interest applied to people who are now indirectly involved in a decision. So not just parties. So what is a participant with a financial interest in a proceeding? The definition of participant under the government code section is two-pronged. It's an individual who lobbies, testifies in person, or otherwise communicates with an officer or employee of the agency for the purpose of influencing the decision-making. And second, has an actual financial interest in the decision. And that part is important. So not everyone who testifies in person at a hearing qualifies as a participant such that these new provisions would be triggered. The person has to have a financial interest in the decision. So under the new law, if an officer is aware that the individual has a financial interest in a decision, the officer is then required to disclose the contributions of more than $250 in the past 12 months and then recuse himself. Likewise, officers must refrain from accepting donations from a participant for 12 months after a decision is rendered. So for purposes of participants, the officer must either have actual knowledge of the participant's financial interests, or the participant reveals facts during the proceeding that make the person's financial interest apparent. In other words, the individual actually gives the officer a reason to know the financial interest. So it's not a guessing game. They need to have a reason to know. And these are facts. These bullet points offer facts that provide an officer with a reason to know. First would be if the individual testifies to having some sort of property interest within 500 feet of the real property at issue in the proceeding. Next, if the person discusses having an economic interest in a business entity that may see a significant increase or decrease in customers as a result of the proceeding. And lastly, the person talks about a business relationship with the applicant that may result in additional services provided to the applicant. What would not constitute a financial interest is if the person makes vague references to an economic interest in the general vicinity of a business entity or real property at issue in the proceeding. So in that case, the official doesn't really have enough information to draw the conclusion that the person has a financial interest. Next slide, please. So we've gone over the legislative changes, and throughout this presentation, we've also applied the guidance that the commission has offered. The regulatory changes can be found online that were recently approved. The FPPC has also issued, as we referenced earlier, the Kendrick opinion, clarifying that SB 1439 does not apply retroactively to proceedings participated in or contributions accepted in 2022. And again, that's available online as well, but we are still waiting on the Attorney General's more definitive opinion on the matter of retroactivity. Next slide, please. And with that, we'll have Craig sort of put all these concepts together with an example.
Okay, this is the point in the proceeding where a number of people have either had their eyes glaze over and go, I don't get this, or get really sort of anxious about all the potential problems that could occur, and we feel you in both cases. So I want to kind of first give you three thoughts about this law that maybe provide a little bit of context. The first is the last issue that Natalie discussed at length was this issue of participants, which is really the first time in which somebody who's not the direct interest in a decision becomes relevant for a conflict of interest analysis. And frankly, for the lawyers and staff in the room, especially, I think participants is going to be the area where there's going to be some mischief with this new law. And I can see situations where, for example, land use project opponents may try to disqualify public officials simply by finding somebody who's got a financial interest in a decision and encouraging them to make campaign contributions. So I think that's an area that really bears watching and study by, especially by lawyers and staff, because I think that's going to become an issue. The second thing is that I think SB 1439 proves the value of having local government participate in the legislative process, especially through our lobbying groups. Having the league and groups like ILG and public officials sort of contribute to this process did create a couple of helpful kind of outs in this law. A couple of places where we can avoid problems, and that's what we're going to kind of focus on in the examples. And so, yeah, the law is draconian, it changes a lot of concepts, but there are ways to do what we need to do and still not be in violation of 84-308. So I want to talk about those in the examples. And then finally, emphasize that in this analysis, just like when we're talking about materiality and the conflict of interest, the normal economic interest kind of conflict analysis, details are really important. Dates and amounts and those kinds of details, as you'll see in our examples, are really important. And so we're included them in these examples to try to help you understand the concepts. So in this example, on April 1st, 2023, Councilmember Watson received a $500 campaign contribution from NCK. And NCK is a developer who has previously had development applications before the City Council of the City of Beverly. NCK has donated to Councilmember Watson's campaign several times over the years in amounts over $250. The president of NCK delivered the most recent check in a fundraising event. So the council member received that check personally in a fundraising event. On April 10th, 2023, all of the city council members received by email a local online newsletter that featured an article about NCK's future development plans within the city, as well as an announcement for a community meeting to gather feedback from residents about a development project. Well, then on April 17th, 2023, the posted city council agenda for the April 20th, 2023 meeting shows an item for the city council to consider a land use application from NCK for a large multifamily housing project in the city. And the question is, if Councilmember Watson goes ahead and participates in that governmental decision to consider NCK's housing project, would that participation violate Government Code Section 84-308? And we're going to kind of walk through the elements of that, but I want to point out one thing that's important for all to keep in mind is this is not, in this example, just a Councilmember Watson issue. It's also an NCK issue because the law requires NCK as a party to this decision, right? The subject, the person who has the land use application pending, the law requires that that party disclose the existence of this $500 campaign contribution in April of 2023, just a couple of weeks before the date of the decision. And that's really important because that's one of those helpful provisions that's in this law that's intended to help officials comply, not intended to get them caught in a kind of gotcha situation. So if Natalie emphasized this concept of knowing versus unknowing, we all know that there are some campaigns that just have a treasurer who opens envelopes and deposits checks and files a report. And there are so many contributions that the office holder wouldn't have any way of knowing every single person who made a donation. So that just the filing of the 460 does not trigger these requirements. In this example, however, we've said that NCK delivered that contribution to the council member personally at a fundraiser. That's going to be a knowing acceptance of the contribution, but it's also creating the situation where the developer has to stand up at the meeting and say, here I am, I made a contribution of $500 to these council members on the dais. So that's a way that the statute is intended to help officials comply. Next slide, please.
Okay, so not to spoil the ending here, but if Councilmember Watson proceeds without recusing himself at this point, he may be committing a violation. But even if this does constitute a violation, is there a way for him to rectify the situation? Is there a way for him to cure the violation? Let's look at the facts. So the operative question here is, did the officer receive the contribution prior to knowing or having a reason to know the proceeding involving the party commenced? If so, yes, it's possible to cure the violation. So here, Councilmember Watson received in person the campaign contribution on April 1st before, he would have had a reason to know, and so he would then, he would then have the option to cure the violation. The next question that's not really relevant here because there were no participants, but it's whether the officer received the contribution from a participant prior to knowing or having reason to know the participant's financial interest in the matter. If so, then yes, he can also cure the violation. The solution here would be to return the excess portion of the contribution or the contribution entirely within 30 days from the time he or she knows or should have known about the contribution and proceeding, allowing him to participate. And do not solicit or accept a contribution for at least 12 months after the decision. So if you've cured one violation, you don't want to commit another. So that 12-month period after the decision is rendered is also important. Okay, next slide.
Okay, so how would we advise Councilmember Watson to proceed based on the facts that we've given in the example? There are two options. One, the careful lawyer or the careful staff member would always advise the council member to disclose the contribution at the beginning of the proceeding and recuse himself from the decision. That's the way under the statute to avoid even being accused of a violation. It is to disclose that contribution and recuse himself from the proceeding. The statute allows, however, for the council member to participate, disclose, participate, and then cure the violation within a very short period of time. This won't, as I'm sure all of you know, eliminate all of the allegations and scuttlebutt that are going to come out about a council member violating the law. But it is a way to avoid getting charged with a violation. So that option is to participate in the public proceeding before returning the contribution, but with the intent to do so. And to do that, these factors have to be met. First of all, the council member has to have known about the public proceeding for fewer than 30 days. Okay, if this was something that was scheduled 2 months in advance and the council member had the opportunity to take steps to avoid the problem, the law is going to expect the council member to have done so in advance. This exception only applies because in our example, the contribution was made on April 1st and the decision was going to be made on April 20th within a 30-day period. Second, the council member must disclose that disqualifying contribution on the record of the proceeding before taking part in any further discussion or decision. Council member at the beginning of the hearing has to say, I received a contribution of $500 on such and such a date from the applicant, from the developer. I intend to return the amount over $250. It has to be done at the beginning. You can't sit through the proceeding, ask questions, participate, and then say at the end, oh, by the way, I had this issue and I'm going to take care of it. The law is very specific that it has to be done before taking part in any further discussion or decision. Third, in that disclosure, the council member has to confirm that he's going to return the amount of in excess of $250 within 30 days from the time he knew or should have known about both the contribution and the proceeding. Now, that date is important, right? It's not 30 days from the date of the contribution. It's 30 days from the date he knew about the contribution and the proceeding. In our example, the only way we can figure out how to make these regulations line up is that date was April 17th when the agenda for the meeting was posted. That was, in our example, the first date that the council member actually knew there was going to be a decision at a city council meeting. That was within 30 days of the date of the contribution. So the council member has to return the contribution within 30 days from that April 17th date. And finally, you've got to actually do what you said, right? You have to return the contribution, either the entire contribution, which might be the best idea, or at least the amount in excess of $250 within 30 days of that April 17th date when the city council agenda was posted. Now, in an abundance of caution, and I'm a cautious guy, I would advise the council member to return it sooner, so that in case somebody comes up with a different date that should have been applicable, or in case there was an email that went out a couple of days earlier informing council members that this decision was coming, something that doesn't show up in our fact pattern, I say do it as soon as you possibly can. And in fact, I would probably have advised that council member to go home from the meeting and put the check in the mail. The other thing to keep in mind, and we're going to talk about this more, is once you cure this problem of participating in the decision where a party gave you a contribution of more than $250, you still have to keep in mind the 12-month fundraising ban going forward. Okay, so there's the contribution prior to the decision and the limits that apply to that. You also have to keep in mind that once this decision is made, for 12 months thereafter, Councilmember Watson and the other members of that council cannot accept a contribution of more than $250 cumulatively in a year from NCK. So there are two parts to that contribution limit. Next slide, please.
That was a good segue to this slide. The question of whether officers can cure a post-proceeding violation. So here the legislature draws a distinction between the knowing acceptance of a prohibited contribution after a proceeding and an inadvertent acceptance during that period. So the question here is, did the officer knowingly and willfully accept, solicit, or direct the contribution during the 12 months after the date of a final decision in a proceeding? If that was done knowingly, then no, you're out of luck. You can't cure that type of violation. Well, if an officer unknowingly accepts, solicits, or directs a disqualifying contribution during the 12 months post-proceeding, the officer may cure the violation by returning the excess portion within 14 days of accepting, soliciting, or directing the contribution, whichever date comes last. So what's important here is that it's a shorter time period. It's a 14-day period to return the contribution. So an example here would be if Councilmember Watson's campaign team sent out a broad fundraising email that a former party to a proceeding received, and this is, a first-time donor and contributed during the 12-month period after a decision was rendered. The party shouldn't have done that, but he did anyway. So absent other facts, that wouldn't constitute willful acceptance. So it is still possible to cure within 14 days under that fact pattern. Next slide, please.
And I think I think one lesson or one tip that arises out of that discussion of the post-decision fundraising ban is, first of all, and this should be obvious to any ethical public official, you can't, on the heels of a decision, run outside the council chambers or or wherever the meeting is taking place, or call the next morning to say, hey, you got what you want. How about making a campaign contribution, right? That post-decision 12-month fundraising ban is now in effect for everybody. It was always in effect in a shorter period of time for appointed officials, but you shouldn't do any direct fundraising from parties for 12 months after the decision. The second thing in my mind that is indicated by this is that it's probably better to have council members, elected officials, appointed officials take a little less of a hands-on role in fundraising. I realize that's not realistic in a lot of small jurisdictions, but I think it's going to be more and more important to trust campaign treasurers and in the handling of contributions, and not have a kind of hands-on approach to looking at every check and knowing then every contribution that has come in for a particular campaign. Again, I recognize that's not always realistic in smaller campaigns, but frankly, not knowing who contributed to your campaigns in some ways is better for the purposes of these new legal provisions. Now, I'm the graybeard in this panel, and I'm the one who's been around a long time, so I'm the one who gets to make you a little madder, because I know that people are not going to be happy with this discussion of participants and what you're going to have to think about in terms of contributors who are participants in proceedings as opposed to the actual direct parties to a proceeding. But I'm going to go ahead and walk through these examples and questions to try to help you understand what is a very complicated new scenario that the law has set up for us. So let's take those same facts that I already gave you: NCK's application for a multifamily housing project in the city of Beverly. And Councilmember Watson is still on the city council, but during the public hearing, people get up and testify about this project, and they disclose the following items. First, Mr. Gershon gets up and reminds Councilmember Watson that he's voted for that council member at every election, and he's actually hosted a fundraiser at his home for the council member in 2022, and he personally donated $1,000 to the campaign at that 2022 fundraiser. And although he lives somewhere else in the city, not close to this project, he thinks the project's going to ruin the character of the neighborhood in which it would be located, and he expects Councilmember Watson to vote no and prioritize the views of the people like Mr. Gershon who elected him. Second speaker gets up and introduces herself as Ms. Richards, and she's the owner of an ice cream shop located just across the street from the property where this housing project would be developed. And she's in favor of the project because she thinks it'll increase customers for her shop. But after Gershon just testified, she feels that it's really important for her to remind Councilmember Watson that she also attended that April 1st, 2023 fundraiser and wrote a check for $300, which is a lot of money for her. And that's because she feels so strongly that this project should be approved. And then her lawyer for the property owner gets up, and Councilmember Watson knows already that that lawyer's client is one of the top donors to a political action committee in town, Keep Beverly Growing, which has supported Councilmember Watson and two other members of the council majority in the past with independent expenditures and a lot of campaign activity. And in fact, that landowner where the project is going to be located has contributed $10,000 to that PAC this year alone. So how do these disclosures affect what Councilmember Watson has got to do under Government Code Section 84-308? If it was me, I would run away screaming from the council chambers and just say, I'm not doing this anymore. But I've never run for office. So Councilmember Watson's probably got different considerations. And so I think each one of these illustrates a different concept in the now law regarding participants to a proceeding. Let's talk about those in the next slide. First of all, the easy issue, the easy kind of red herring issue to throw out is for elected or appointed agency officers, we're talking about direct contributions to those candidates are covered under 84-308. Donations to political action committees, donations to independent expenditure efforts are not covered by this law. And so that last example of the landowner giving to a PAC is kind of just something we don't have to be concerned about. It's a perception issue, obviously, but it is not, does not create a recusal requirement under 84-308. Secondly, the donation date. We had an example where the large donation was made in 2022. Right now, the opinion of the FPPC is that this law applies for elected officials to contributions made after January 1st of 2023. The donation amount is relevant because the ice cream shop owner, I can't remember now if she's Richards or Gershon, but anyway, the ice cream shop owner made a contribution of $300. So the amount that exceeds obviously is that $50 that would have to be returned or create this recusal requirement. The decision at issue is a land use permit, and that is clearly covered by the list of decisions that are covered by 84-308, the list of proceedings. And the decision date that's relevant is within 12 months after the contributions for these participants, which would trigger a recusal requirement because Ms. Richards made a contribution only a couple of weeks earlier that exceeded $250. So, and then the question is, which I think you've already guessed, we're not talking about parties here. We're talking about participants because the people who are listed all have kind of a tangential interest in the particular decision at issue. Gershon does not appear to have any financial interest at all because he lives in another neighborhood and has no interest in the property. Richard's business is across the street, and she therefore likely qualifies as a participant because a participant with a financial interest means, among other things, somebody who has business within or real property interest within 500 feet. The lawyer would be considered an agent, but contributions to that PAC do not create the same conflict of interest problems under 84-308 that they would have created had the property owner written a check directly to the council member. So as you can see, in a big land use hearing where there may be various people with various types of interests, there could be all kinds of issues that are going to have to be analyzed under 84-308 when appointed and elected officials accept contributions in excess of $250. Next slide, please.
So as Craig just hinted, we've identified in our fact pattern at least one participant, Ms. Richards, from whom Councilmember Watson received a contribution. So how can a local elected official like Councilmember Watson return the contributions from participants in a timely manner? So just to recap, a participant is an individual who lobbies in person to a local officer directly testifies in person before the agency, like Ms. Richards, or otherwise acts to influence the agency members for purposes of influencing a decision in the proceeding, if that person also has a financial interest, which, as we've noted, Ms. Richards does because of her nearby business. We've also identified 2 knowledge issues with participants. So unlike parties to a proceeding, participants are typically not required to disclose their contributions to agency members. So an official might not know at the time about the contribution. In addition, it might be difficult to identify a potential financial interest if the speaker doesn't volunteer sufficient facts about her economic interests. But here, there's a solution. Ms. Richard has volunteered that information. She's told us that she contributed on April 1st in person, which would mean that Councilmember Watson had knowledge of the contribution. And 2, she talked about her potential financial interests. She said 2 things. She said that she has a business that might benefit from this permit being approved, and she's noted that it's nearby. And so there is also knowledge of a financial interest. So what does the council member have to do? An officer who has willfully or knowingly received a contribution from a participant and knows or has reason to know that the participant has a financial interest in the proceeding would violate the government code section when he participates in the proceeding. So here there's an option that we've noted. The period to cure the violation is the same as it is for parties. It begins within 30 days after he learns about the contribution and the participant's financial interest in the proceeding. Now, if there were to be a post-decision violation, again, that's the shorter period within 14 days of accepting the contribution, only if the officer did not knowingly and willfully accept the prohibited contribution, and which continues for 12 months after the decision is rendered on the permit application. Next slide, please.
Okay, to kind of wrap up this portion of the presentation, we're going to talk a bit briefly about the future of SB 1439. We're going to talk about some recommendations for how to deal with this moving forward. And I note that there are 20 plus questions in the Q&A function below that we're not going to have time to in the hour address, but we will work with the ILG staff to come up with answers to those questions and maybe try to group some of them together and publish those with the materials for this session. So we will get to your question. We may not answer it right now as we're going through the presentation. First of all, litigation. There was a lawsuit filed by a coalition of business groups in Sacramento seeking to have the statute declared unconstitutional. There is an argument that some lawyers believe more than others that about the constitutionality of the statute. The trial court did not agree with that argument and did not strike 84-308 down on that basis. There's doesn't have any precedent value because it was a trial court, and appellate courts have not yet addressed this issue, but that may be coming. There is a pending Attorney General opinion that the author of the bill asked for on the issue of retroactivity. We told you before that the FPPC determined that this applies for elected officials to contributions beginning on January 1st of 2023, which in my mind is the only approach that makes sense. The author apparently didn't agree with that interpretation, and so they've asked the Attorney General to opine whether, you look back 12 months from January 1st of 2023. We, Natalie and some others provided some, I think, helpful input to the Attorney General on those issues. We hope that the Attorney General will issue an opinion that agrees with what the FPPC already did. However, I note that in the time that it takes the Attorney General to issue an opinion, the clock is already ticking. We're, in the middle of July already, so it becomes less and less of a relevant issue. So some recommendations. First of all, there's been a lot of questions about this, and I want to emphasize it is not the obligation, as I said before, of staff of a public entity, specifically the filing officer and my friends who are city clerks, to track contributions and keep track of all these issues. The law does not impose that obligation on filing officers. That being said, there may be good reasons in a lot of jurisdictions that you want to do this. For example, I know of a jurisdiction in California that has a situation where a significant contractor with the city made campaign contributions in pretty large amounts to multiple members of the city council prior to a previous election. And those campaign contributions would disqualify under this law a significant, probably a majority of the city council, unless they returned the amounts in excess of $250. Those amounts have already been spent because the election is over. So it would be difficult for council members to return those excess amounts, and they would, have been disqualified by this particular law. So, and that could cause business problems for the city going forward. So there may be reasons why staff wants to come up with a way to track. And if you just Google the issue, there are a number of public agencies that have already created some forms that are available online to as a way to sort of structure the thinking. But the law doesn't require that. Campaign committees should really carefully monitor contributions. And personally, I think if at all possible, candidates should limit on a personal basis, limit contributions to $250 or less annually, because that's the way you avoid the fundraising ban. That's the way you avoid the recusal requirement. Just don't accept any contribution in excess of $250. I recognize there are people out there right now saying that's not practical. I understand that. I'm just telling you, with the dollar amounts that are in the statute, the way to avoid the problem is to just self-limit your contributions to $250. Second, committees need to be really careful with the cumulative contribution column on the Form 460 and make sure that multiple small donations from a repeat donor do not exceed $250, or when they do, that the candidate, the appointed or elected official knows that. As I said, public agency staff, I would say, should consider whether it's practical to compile a list of donors for each elected and appointed official who file campaign contribution reports above the $250 limit. And elected and appointed officials should carefully and publicly disclose and return excess portions of prohibited contributions in a timely manner in order to take advantage of the cure provisions that we've talked about. So there's a way to prevent the violation going forward by not accepting that contribution in that amount or simply returning it. There's a way to cure the violation within a brief period after the time it occurs, and that's to return that excess amount. But the $250 limit is a pretty bright line rule. And with that, we'll turn it back to Melissa to wrap things up.
Great. Thank you so much, Craig and Natalie. And thank you for everybody on the phone and for all your questions. As Craig mentioned, we obviously don't have time to get through all of those this afternoon, but we'll work with the team to get answers to those, distribute along with the rest of the materials. I do, if you have time, and will humor me, Craig, I have seen quite a few questions around a certain scenario that I just would love for you to share some thoughts on if you are willing. There's quite a few people are asking questions around a scenario where we'll just say a developer, or an interested party of some sort makes campaign contributions to, say, the whole council or to a quorum, a majority of the council. What would be your thoughts in that scenario? Because you would either be facing a recusal of a majority of your elected body or appointed body, or a need to run through some of these curing processes. So just any thoughts on how to prevent that, or how to handle that if that scenario presents itself?
Yeah, I saw one or two of those questions. I mean, the way to prevent it is as we've suggested in the tips, limiting contributions. That's to me the only way you can really prevent that, looking forward. But if you have that situation where, excuse me, more than a quorum or a quorum of the body is going to have to recuse themselves from a decision, and they don't want to return the excess portions of the contributions, we just have to remember that this government code section is part of the Political Reform Act. It's essentially, and it's going to be enforced by the FPPC. And so, although I can't cite you a regulation right now that says it, I believe the only common sense interpretation is that the rule of legally required participation would apply, and we would go back to the same thing we would do if more than a quorum had a conflict of interest, and draw straws or at random bring back the members. If I was the agency attorney in that scenario, before I got to that point, I would certainly try to use the power of persuasion to convince council members or public officials to return the excess amount first, so we didn't have to get there. But I think that's under your question. I think the only possible interpretation is that the rule of legally required participation would kick in at that point.
Perfect.
Otherwise, I talked about mischief.
Yeah, right. That's where my head
Otherwise,
is going. I'm like, it
mischief could
be that
occur,
folks
right?
Yeah.
Project opponents could create a situation where a decision
Strategically.
could not be made by writing a check for a few $100. And so that can't be the outcome of the statute.
Right. Which was where my head was going when I was seeing some of those questions come through. So appreciate your thoughts on that. Just in terms of, you obviously mentioned the pending court case and opinion from the Attorney General's office. But are you aware of the FPPC intent to release any FAQs or any additional resources for folks in this space?
Natalie, what do you have some ideas on that?
I'm not aware at this point. If I assume they'll follow up.
We did cite the new regulations are on one of the slides, so you can read the new regulations. They're usually pretty good with their educational material, so hopefully they'll, especially things where they're focused on it, like this particular issue. So hopefully they'll issue some helpful education.
Perfect. And we'll keep an eye out for that too, and share that with folks on the line in our list if we see anything come out in terms of additional guidance. Okay, just want to share some additional resources with you all. This, as I mentioned early on, this is part of a larger program focus for us. And so we have a number of resources on leadership and good governance, as well as additional resources on ethics and transparency, some of which our attorney friends on the line have helped us write and update. And then we also, obviously this has a public facing component. And so just want to flag that we also do a lot of work and training around community engagement. We have one coming up later this month. So if you're interested in figuring out how to navigate that side of things, please join us on that training as well. If you aren't already hooked into our networks, please join our newsletter list, follow us on social media. We're on LinkedIn, Twitter, and Facebook. Those are the handles there. So please stay connected with us. And that's another good way to keep on top of additional trainings we're doing, or as we come across additional resources, we can share those with you all. Quick reminder that we did record this session, and we'll be sending that out along with the slide deck and hopefully some responses to the questions that we weren't able to get to today in the near term. And then just want to share contact information so you can follow up with any of us as needed or wanted. But I just want to thank everybody who joined us this afternoon. I know it was quick and a lot of information, but hopefully you'll have some good tips and takeaways and recommendations to take back to your agency. And Craig, Natalie, thank you so much for sharing your expertise with us and walking through a very complex topic in a quick turnaround. So thank you so much. Any final thoughts for the audience before we close out today?
Thanks to the ILG and Melissa and Taylor, and for everybody for participating.
Yeah, thank you to all the organizers and all the attendees.
All right. Well, thank you, everybody. I hope you all have a fantastic afternoon.